Thanks very much for downloading this webinar. My name is Philip Patterson and I'm a barrister at Gatehouse Chambers. My practice covers insolvency, company law and general commercial dispute resolution. And in this webinar, I'm going to be looking at the recent decision of the Supreme Court in THG plc and Zedra Trust Company, Jersey Limited. The judgment was hotly anticipated by English company lawyers and those whose practices cover shareholder disputes. As we will see in due course, in February 2024, the Court of Appeal handed down a judgment which sent shockwaves through this part of the profession. That judgment suggested that 40 years of received wisdom concerning unfair prejudice petitions, and more specifically the question of whether a statutory limitation period applied to them, was wrong. The Supreme Court granted permission to appeal on the 23rd of May 2024, and the appeal itself was heard on the 17th and 18th of February 2025. We then waited a year for judgment, which was eventually given on the 25th of February 2026. What we learned from that judgment of the Supreme Court was that the 40 years of received wisdom was in fact right, and that unfair prejudice petitions are not subject to any statutory limitation period. Now, this was the principal question for which an answer was anticipated, but the judgment also gave some strong hints as to what had caused the long delay, and I think there were probably at least three. First, it highlighted the complexity of the issues with which it was grappling. Very long-standing statutory provisions on limitation had used terms which were not properly understood and had never been analysed in any depth in the authorities. Second, the Supreme Court was prepared to roll up its sleeves and undertake a particularly detailed analysis of those provisions which had previously been lacking. And this has produced a judgment which has, at least in my opinion, implications that go far beyond unfair prejudice petitions, and in fact have implications for jurisdictions other than our own. Third and finally, the Supreme Court was actually split 4-1 with a powerful dissent from Lord Burroughs. All three of those factors, I think, would have contributed to the length of time it took to produce the judgment. So whilst it was always anticipated that this would be an important judgment for the Supreme Court, in my opinion, its importance may very well have been underestimated, at least prior to reviewing the judgment itself. Now, often in these second appeal cases, the facts can become easily forgotten. But in this case, there are some important details in them upon which we need to focus. And so I've dedicated a couple of slides to the question of the facts. The Hut Group is a global retailer and brand owner which is headquartered in Manchester, UK.